denying that Madison was alone with Aiden. Would the video be wrong?
Objection, Your Honor. Relevance for suppression.
Overruled.
Do you understand the question, Detective Nordstrom?
Not really. You're asking if
So let me.
Mr. Ely said that his son was ever left alone with Madison.
Let me ask it
I
again.
said that he indicated that he was not left alone with Madison, only with Emily.
Let me ask this question again. If we watch this whole video, those two DAV files you've got, and nowhere
Yeah.
on that video does it depict Commander Ely saying Aiden was never left alone with Madison. If that doesn't appear in that video, would that video be wrong? Would that be the wrong video we're looking at?
We're looking at the same video as the one the prosecutor provided to me.
So would the video be accurate?
The video is accurate.
Okay. So we'll take a look at the video. We'll take a look at the video. Before you interrogated Commander Ely, you had an interview with Laurie Dowdell, right?
That's correct.
Okay, and you spoke with her at length about her allegations against Aiden,
Yeah, I did.
and you listened to her during that interview,
I did.
and you empathized with her as well.
Empathize how?
You displayed empathy for her story because that's something that you do as an investigator of child crime, right?
I'm sure I did. I did that with Mr. Ely also.
Okay, and we'll see that in the interview, will we? That you displayed empathy for Commander Ely.
Yes.
Okay, well, we'll take a look at it. We'll take a look at it. When you first approached Commander Ely, what school was that at?
I don't recall the name of the school off the top of my head. It was an elementary school in Stonington, and I remember going there with Officer Page from the Stonington Police Department.
Okay, and who else met you there?
The grandparents were there.
Because you met Dennis Dowdell and Virginia Dowdell?
That's correct.
And Dennis,
I spoke to Dennis specifically.
yeah, Dennis told you that he used to be a police officer as well, right?
Yes.
And so this school was a place where Commander Ely was expecting to come and pick up his daughter, right?
That's correct.
And he knew that coming in.
I did.
And when Commander Ely arrived, his daughter wasn't there, right?
Correct.
He saw you there with Dennis and Miss Officer Page.
Correct.
And you walked up to Commander Ely and you said, "You're not picking up your daughter from school?"
No, I advised him that I was there because his wife was going to hold on to the daughters until she could apply for a restraining order, and asked that he come speak with me regarding some allegations.
Okay, so implicit in that communication is his daughter wasn't there at school to be picked up, right?
Right, the daughter was not there.
And he began crying when you said that, didn't he?
At the scene, I don't remember. I remember him being emotional. I don't know if he actually cried.
Okay, I mean, you told me you reviewed your report. You also documented that interaction. You said he cried.
It's in my report that happened, yeah.
Okay. And so he became emotional about not being able to see his daughter.
Sure.
And you also told him that his daughter was down at the police station, right?
I don't believe I said that the mother had made a report. I don't believe I ever told him the daughters were at the police station.
You didn't tell him that?
I don't recall saying that.
You asked him to come into the police station.
That's correct.
And then you took him into this interrogation room you just described, the small room with 3 chairs.
Yes.
And as you entered that interrogation room, right, you obviously digested this report you received from Laurie Dowdell.
Yes.
And one of the things Laurie Dowdell told you is that she believed Commander Ely had somehow tried to hide this report and encourage Madison not to actually share this report with anybody else. Laurie told you that, right?
That's correct.
And that's something you suspected Commander Ely of as you sat him down, was that he knew about this allegation and that he was trying to hide it, right?
Honestly, I did that as a story at the time. I didn't come to any conclusions at that point.
Oh, okay, so you're going in with an open mind then, were you?
Yes, that's generally what I do.
But you received this information from Laurie Dowdell that we just discussed. That she believed that Commander Ely was trying to hide a crime. And when we're talking about the open mind you went into there with, I think you said on no less than 3 occasions, children don't make this up. So was that something you believed, or was that something you were just telling Commander Ely to get him to talk to you?
No, that is something I learned when I became a forensic interviewer.
Okay, so that wasn't a genuine belief, that was a tactic that you used?
No, that's a belief. I believe that. I was trained that way.
Okay, so I'm just trying to reconcile that point of view with what you just told me about coming into Commander Ely's interrogation with an open mind.
Yeah, no, that is actual factual to me, that children around the age of 4 do not have the ability to retain a lie, and that's what I told them.
Okay, so you did believe that he was trying to obstruct some kind of investigation into Aiden when you sat him down to speak to him, because you believed that allegation actually happened.
I didn't know. I was talking to him. My belief is not what I believe, it's what actually occurred, and I try to get to the bottom of that by interviewing people.
Okay, I'm asking you about your belief right now, so what was your belief?
I don't recall what my belief was at that moment.
Okay. You also engaged agents from the Coast Guard Investigative Services during your investigation into this?
I did at some point, yes.
You asked them to seize and extract data from Commander Ely's work phone, right?
I don't believe I am. Did you do it?
Hold on, there's an objection. What's your objection, trial counsel?
The relevance of this question as it relates to the suppression of the statement on December 23rd, 2015.
Defense counsel, what is the relevance of this?
It goes with the rights of us that are required when civilian law enforcement organizations are conducting investigations in parallel and tandem with military law enforcement organizations interrogating military members.
When Agent Nordstrom, when did you engage Segis? On December 23rd, before you interviewed him?
I'm sorry, I can't hear you very well. What was that?
This is Commander Casey, the military judge. Can you hear me now?
I can.
So, when did you engage Segis? Before or after you interviewed Commander Ely?
That was sometime after interviewing Ely. It was not around that date at all.
Alright, the objection is sustained. Move on, counsel.
The time you interrogated Commander Ely, you knew that he was a commander in the United States Coast Guard, correct?
I did know that from his ex-wife telling me that.
Yeah. So he was in the military service.
Correct.
So when you sat Commander Ely down in that interrogation room, one of the first things he did again was he cried.
That's correct.
He was visibly distraught, right?
Yes.
His voice was shaken.
What's that?
His voice was, I guess the word shaking, but his voice was unsteady.
I just noticed him to be crying.
He certainly did not appear comfortable, right?
He was not comfortable with the allegations, no.
No. And they were allegations about his son.
That's correct.
And again, before you began interrogating him, you didn't give him any kind of advisement that he had a right not to answer your questions.
No, I did not.
You didn't advise him that he could go talk to a lawyer if he wanted to.
No, he wasn't a suspect, so I didn't need to do that. He wasn't in custody.
Okay, I mean, you say that, but you also just told us that there was an allegation out there that Commander Ely had essentially encouraged his daughter not to report this allegation against his son, right?
You broke up right before that. Could you say that again, please?
You just said he wasn't a suspect just now in answering my last question, but again, you talked about this allegation that was out there that Madison had told her dad that Aiden did these things, and Dad then tried to hide it, right? You knew about that allegation.
Yes, I knew about that allegation.
And
But then that makes him a suspect.
And you confronted Commander Ely with that allegation, right?
Sure.
Sure or yes? I mean, do you recall doing that?
I'm sure I did, yeah. It doesn't make it a crime to tell the daughter not to talk to us first.
No? Okay, so that's not obstruction of justice?
Counsel, move on.
It could be. It's not something we generally.
We're not going to debate. Continue, counsel.
And again, the tone you took with Commander Ely was different than the tone you took with Laurie Dowdell when you spoke to him, right?
No, I don't think so at all.
You confronted Commander Ely on numerous occasions about how you believed children,
How what?
how it is that you believe children that make these allegations.
You're breaking up, sorry. I heard children make allegations.
You confronted Commander Ely on numerous occasions during this interrogation with the statement that children don't make this stuff up, right? You kept telling him that.
Yes, that's correct. That's correct. Yeah.
You also cut him off on numerous occasions, and as he was talking, you did cut him off and had him with a question, right?
Probably. Yeah, I do that.
Yeah. One of the examples of that would have been when you asked if Aiden was alone with Madison, right? You didn't actually let him answer that question.
I don't remember that exact occasion.
And just let me just ask you this, right? If we look at this video, this interrogation, and that interrogation then shows that Commander Ely never made a statement. Aiden was never left alone with Madison. Would your report summarizing that interrogation be wrong?
Yes, Your Honor.
What's the objection, trial counsel?
This has been asked and answered.
That particular question hasn't been asked, Your Honor. I'm coming to the end.
My report's an accurate depiction of the injury.
That's her answer. That she believes her report is an accurate depiction. So I'm going to sustain your objection, counsel. I understand. I will be reviewing the interview myself.
May I have just 1 second, sir?
Sure.
Going back to this interrogation, Detective Nordstrom, during that interrogation, Commander Ely actually called his son to come into the station while you were there.
He did.
And one of the things that Commander Ely told you during this interrogation was that he was having trouble remembering the events.
Yes.
And he wanted to do his best to help you, right?
Yes.
And he said he was concerned about his daughter's welfare.
That's correct.
And his son arrived during Commander Ely's interrogation, right? His son arrived at the station when Commander Ely was still there.
He did.
And Commander Ely facilitated your access to speak to his son.
He did.
And just to be clear, I know I asked you whether or not you suspected that he had told, tried to prevent Madison from reporting Aiden. Let me phrase that more appropriately. You talked to us about the beginning of your interrogation at the police station, and you said you'd already received this report from Laurie that Madison had tried to tell her father that Aiden did these things to her, and her father tried to hide that, right? We talked about that.
Yes.
And you knew these facts and these allegations when you confronted Commander Ely at Madison's school as well, didn't you?
That's correct.
And this opinion that children under the age of 4 cannot retain a lie, where does that come from?
Objection, relevance. It's a suppression motion.
Yeah, what's the relevance, counsel?
It's a statement she gave during her interrogation of Commander Ely, sir. One of the tactics she described she uses during interrogation.
Yeah,
that goes to the voluntariness of
that was
this.
something I learned.
Hold on. Ms. Nordstrom, this is Commander Casey again. I'm trying to deal with this objection, so please don't answer. Go ahead, defense counsel.
Do you need to give my response again, sir?
Yeah, please.
So, this statement, that children under the age of 4 cannot retain a lie, that's a statement that Detective Nordstrom said she repeated to Commander Ely on numerous occasions during this interrogation as an investigative technique designed to essentially confront a suspect during the interrogation. It goes to the voluntariness of the response he gives, and to test whether or not that's an appropriate tactic. I need to know where this opinion comes from.
I don't think you do, counsel. Sustaining that objection. She has stated on the record that that's based on her training, that that's her belief, and she multiple times asked your client during the or stated to your client that children don't lie. You have that out in evidence. So as far as going to your voluntariness analysis, I get the evidence that you have. Her belief of why that's true has no relevance to me.
Just to be clear, Detective Nordstrom, when Commander Ely arrived at the police station, he didn't actually know why he was there, right?
I told him I'd speak to him about allegations that were made against his son.
You hadn't told him that Madison had made allegations of sexual abuse against anyone when he arrived. He didn't know that, did he?
I don't recall if I told him everything at the school or if I waited till the interview.
Okay, I thought you just said you reviewed all of this. Let's talk about the stuff you said you reviewed anyhow, okay? Because I thought you said you reviewed your report. What else was in that?
My reports are quite lengthy with Mr. Ely, so I've read a lot of things.
Okay, so what have you read? What's in that case book? You got reports, right?
I do. There's lots of reports on Mr. Ely for previous incidents and incidents after this case.
Okay, are there written notes in that report that you used to refresh your memory?
There's no written notes. No, just I reviewed my reports.
Counsel, where are you going with this?
Yeah, I'm testing this witness' credibility, Your Honor.
Again, I have the video of this interview, correct? This is a suppression motion to statements made. Her credibility as to her beliefs, I don't see the relevance to whether there's a voluntary statement.
Well, to be clear, can I put the phone on mute real quick, Your Honor? I don't know if that cuts off the trial counsel or not, but...
It will.
Okay, well, let me...
Yep, go ahead. We're at a 39A. It's fine.
The key part of this suppression motion isn't just the video recorded interrogation. The court has the benefit of watching.
Yep.
They showed them their statement. It's the interaction with the school that we don't have the benefit of the video for.
Sure.
And we may supplement this motion with an affidavit from our client exhibited for the limited purpose of contesting the voluntariness of the statement that talks about what actually happened at that school. And so, yes, Detective Nordstrom's credibility is important.
Okay, so you want to ask her about... She's already testified as to what happened at the school and what she has said. Right?
Yes, sir.
Okay, and where else are you going with it then? We have her testimony as to what she claims happened at the school.
I'll bring this up in argument again, Your Honor, but what I keep getting is she can give you certain answers to certain questions, and then other questions I've asked, it's been, I don't quite recall, I have to go back and look at my notes. And so it just begs the question, when the witness tells us, say, I reviewed all this stuff before testifying today, and all of a sudden there are gaps in her recollection of her actions, what did she actually not review? That's what I'm curious about.
I am not curious for the purposes of this motion.
Yes, sir. One of the things Commander Ely told you, Detective Joseph, when you first sat down in that interrogation room at the Drug Police Department, is that he thought maybe his daughter's made an allegation against Margaret or something of that ilk, right?
Yes.
That's all I ask.
Okay, trial counsel, before I have just a couple follow-on questions for Detective Nordstrom. It's your motion, so I'll give you the last opportunity to ask questions, but before I do, Detective Nordstrom, this is Commander Casey, the military judge again. Can you hear me?
I can.
Okay, so on 23 December 2015, at the elementary school, do you recall, were students in school that day, or was it just a drop point for a custody exchange?
I believe they were in school that day.
Okay, and do you have any personal knowledge of was it your understanding that Commander Ely was there to pick his daughters up after school, and that's when he would essentially, attain custody as per a custody agreement that day after school? Is that right?
Yeah, I don't recall why he was there at that time.
Okay. And why was Dennis Daniel there?
He was he was supposed to drop the girls off, I believe, for the handoff. Like, he would hand the kids off for them.
At school?
Yeah, because I believe this was they had the weekends. I didn't review the custody agreement that they had. I'd written some of that stuff up. I believe they had 50-50 custody, and they just ended a weekend visit where the grandfather would drop the daughter off at school, and Mr. Ely would pick him up from school that day.
I'm not trying to twist you, Detective Nordson. That makes no sense to me, because if you're dropping off at the beginning of school, that would be in the morning, and then the accused would come in the afternoon at the end of school. And if you don't, that's your answer. I'm just trying to get some substance.
I don't know why he was there that early. I don't recall.
Okay. Thank you. Trial counsel?
Thank you, Your Honor. If I may, Detective Nordstrom, was Dennis Daniel there to identify Commander Ely to you?
Yes, he was there to help point him out, because they didn't know who he was.
All right, thank you, Your Honor. I have no further questions.
Okay. Detective Nordstrom, this is Commander Casey. I want to thank you for your testimony here this afternoon. We are set to go to trial at the end of January. I will remind you that as this case continues, please do not discuss your testimony with anyone other than counsel for the government and counsel for the defense. Do you understand?
I do.
All right. Thank you, Detective Nordstrom. We're going to hang up here from Washington, D.C.
Thank you.
Thank you. Okay.
Just to clarify, I'm hanging up, right?
Okay, yes, please.
All right.
Okay, Detective Nordstrom, are you still there? All right. Detective Nordstrom has hung up. Trial counsel, do you have any additional witnesses or evidence?
Yes, Your Honor. At this time, the government would like to call Special Agent Adam Niagara.
Very well.
Asking Special Agent Niagara to call in the team's conference line.
Okay. Chief. I'm sorry to ask you to do this. Can you go in the conference room back here and just grab my water bottle? It's this big silver. It's on the table. Thanks.
Good afternoon, Special Agent Niagara. Can you hear me? Yes, sir. Okay, good afternoon, Special Agent Niagara. You're in the courtroom now in the Article 39A session in the matter of United States v. Commander John Ely. You and I spoke on Commander Brian Tyler, the prosecutor. In this case, you're with the Honorable Judge Paul Casey, who's the presiding judge in this matter. He is in Washington, D.C. with the accused and his defense team, as well as an FCC counsel. I am here in Alameda, California, and participating in the Microsoft Teams application with a approximately 60-inch television in front of me where I can both see and hear the courtroom in Washington, D.C. My co-counsel, Lieutenant Brandon Smith, is in Boston, Massachusetts, at the E1 Legal Office, participating in a similar setup via Microsoft Teams application. And Lieutenant Commander Mike Crow is in Norfolk, Virginia, participating via Microsoft Teams. There's also a special legal counsel participating in Seattle, Washington. Special Agent Niger, could you please describe the location that you are sitting in right now?
Yes, sir. I'm sitting in Hamilton Hall, room 215 at the United States Coast Guard Academy in New London, Connecticut.
Is there anybody else in that space with you right now?
There is not.
Are there any papers or documents in front of you?
Yes, sir.
Okay, I'll ask you to please put them away and keep them. Do not refer to them unless I ask you to. Okay.
Okay.
If you could please let me know when that's completed.
All set.
All right, great. Thank you, Special Agent Niger. So are you currently in a space now where you can testify freely and honestly?
Yes.
Special Agent Niger, please stand and raise your right hand. Do you swear that the testimony you shall give in the matter now and hearing shall be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you, Special Agent Niger. You may now be seated. Your Honor, if I may.
Please.
Please state your first and last name and spell your last name for the record.
Adam Nigro, Nigro.
Are you currently serving on active duty in the U.S. Coast Guard?
Yes, sir.
What is your current rate or rank?
I am a CWO4.
What unit are you currently assigned?
Currently assigned to the Coast Guard Investigative Service Resident Agent Office in New London, Connecticut.
Coast Guard Investigative Service, is that sometimes referred to as CGIS?
Yes, sir.
And what is your title with CGIS?
I am a special agent with CGIS.
And what are your responsibilities as a special agent?
As a special agent, our primary responsibility is conducting criminal investigations. Those investigations are related to violations, alleged violations of the Uniform Code of Military Justice, as well as violations of U.S. Code that have a maritime nexus or a Coast Guard interest.
And how long have you served as a Coast Guard special agent?
I began serving as a special agent when I graduated from the Federal Law Enforcement Training Center in January 2009, after which I was first assigned to the Coast Guard Investigative Service Resident Agent Office in Kodiak, Alaska from 2009 to approximately 2011, after which I was assigned to the Coast Guard Investigative Service Resident Agent Office in Beaumont, Texas, until approximately June 2015, where I was subsequently transferred to the office where I'm presently assigned, which is the CGIS office in New London.
Special Agent Niger, you mentioned FLEX. Is that the Federal Law Enforcement Training Center?
Yes, sir.
And is that where you went through your initial training? Is that correct?
Correct. Our initial training consists of the FLEXI's Criminal Investigator Training Program, followed by the Naval Criminal Investigative Services Special Agent Basic Training Program.
As part of that training, interviewing subjects as well as non-subjects.
Yes, sir.
Approximately how many interviews have you conducted throughout the course of your career?
I don't know the exact figure, but it's numerous. We typically do a couple or a few interviews every week, so I couldn't even venture a guess.
And those include interviews of subjects as well, is that right?
Correct.
Right. Special Agent Niagara, I want to direct your attention now to June 18th of 2018. Were you serving on active duty as a Coast Guard Special Agent on that date?
I was.
Did you have an opportunity to interview the accused in this case, Commander John Ely?
Yes.
When did you interview?
It was June 18th, 2018, I believe.
Could you tell how did that interview come to happen?
I contacted the accused prior to the interview. Basically asked, or informed him that we'd like to schedule an interview. He had, I believe, told me that he wanted to look at his schedule, and we subsequently corresponded about dates that would be mutually convenient. I think that initial contact was on June 12th. Subsequent to that, we scheduled the interview for the following Monday, which was June 18th, and it was conducted in our office in Hamilton Hall at the Coast Guard Academy.
Could you describe the location where that interview took place?
In our office, the CGIS office is divided up into essentially 4 spaces. The first space, which is room 215, which is where my office is, there's an adjoining interview room, and so the interview was conducted in that room on that date.
Once again, this was at the Coast Guard Academy, is that correct?
Correct.
And was that a location that the accused was comfortable with or that he's been to before?
I don't know, I couldn't say how comfortable he was there, but I know that he had previously worked at the Coast Guard Academy.
So he was assigned to the Coast Guard Academy, is that right?
Correct. Not at that time, but in a previous assignment. I believe at the time of the interview he was assigned to Coast Guard Sector New York, or Coast Guard Sector Long Island Sound.
As part of your interview with the accused, did you go over a 31 Bravo form?
Yes.
I previously sent you what is an enclosure to the government's response to the defense motion to suppress. This is entitled Rights Waiver, Commander Ely. I sent that form to you yesterday. The form is dated June 18th, 2018. Did you have an opportunity to review that form?
I did.
Does it fairly and accurately depict the form as you completed it with the accused on June 18th, 2018?
Yes.
How was it that you went through that form with the accused on that day?
I'm sorry, can you repeat the question, sir?
Sure. How is it that you went through and reviewed that form with the accused on June 18th?
After we sat down in the interview room, I believe we completed our interview log, captured contact info from the accused, and then I informed him that we would be reviewing the form, and after which I reviewed the form with the accused, and after the review of the form, he indicated by signing the block, indicating that he would sit down and answer our questions and make a statement.
Now, there's his initials on the side of Section A.
Yes.
That's his signature in Block 3.
Yes.
The accused appeared to understand what you were saying to him while you reviewed that form with him.
Yes.
Did he appear comfortable to you at that point?
Yes.
Did you seem to understand what was going on?
Yes.
Once again, the accused agreed to speak with you at that point.
Yes.
Was the accused ever in custody throughout that interview?
No.
Was he free to leave at any time?
Yes.
Was he ever told that he couldn't leave or couldn't speak with counsel?
No.
Was he accused in uniform during the interview?
He was.
Did you ever raise your voice at the accused?
No.
Did you ever threaten him?
No.
Did you brandish a weapon?
No.
long did this interview take place, or take?
It was approximately 52 minutes.
Special Agent Niger had previously sent you two video files, which were identified as the following. The first, Ely_Nigro interview part 1, and that consisted of 1,048,544 kilobytes. It appeared to be 27 minutes of your interview. The second was entitled Ely_Nigro interview part 2, consisting of 978,058 kilobytes, and it appeared to be 25 minutes of your interview from June 18, 2018. Did you have an opportunity to review those files and review the interview video that you conducted of the accused on June 18, 2018?
Yes.
Do those videos fairly accurately depict the interview that you conducted of the accused on June 18, 2018?
Yes.
After your interview with the accused on that date, did the accused come back again to do a subsequent interview with CJIS?
Yes.
And he was asked to do so, and he voluntarily came back?
Yes.
Thank you, Special Agent Niger. I have no further questions at this time. I believe the defense has some questions for you.
Thank you.
Hey, good afternoon, Special Agent Niger.
Good afternoon.
When Commander Ely came in to speak with you in June 2018, Mr. Rice advised him, you didn't advise him that he was suspected of obstructing justice, right?
Correct.
And again, during that interrogation, you never stopped to advise him that he was suspected of lying to you?
Correct.
And he answered all of your questions during this interrogation, right?
So, can you repeat that?
Commander Ely answered all of your questions during this interrogation, right?
Yes.
That's all I asked.
Trial counsel, do you have any follow-ups?
I do not. Thank you, Your Honor.
All right, Special Agent Nigo, this is Commander Casey, the military judge. Good afternoon.
Yes, sir.
I do not have any questions for you either. I want to thank you for being available to provide your testimony this afternoon. We are set to go to trial at the end of January. As long as this case continues, I'll just remind you, please do not discuss your testimony with anyone other than counsel for the government or counsel for the defense. Do you understand?
Yes, sir.
All right, thank you very much. You can please hang up. And again, I want to thank you for your availability.
You're welcome. Thank you, sir.
Yep.
Sign off.
Agent Nigo, are you still there? Okay. Special Agent Nigo has hung up. Trial counsel, do you have any additional evidence?
Thank you, Your Honor. The government does not have any further evidence to put forth.
Very well. Defense counsel, do you have any additional evidence?
We'll be supplementing our enclosures with an affidavit, Your Honor.
Okay.
Again, for the limited purpose of contesting the voluntariness of Commander Ely's statements.
Okay. Today is Wednesday. Can that be provided by Friday?
Yes, sir.
Okay. Thank you. Okay, trial counsel, I'm ready to hear argument.
Thank you, Your Honor. The government referred to you on our written response, but just to highlight, both of these interviews were not the product of coercion or intimidation, that they are voluntary statements from the accused. Part of the analysis, Your Honor, I would argue, as we did in our response, is the accused, his experience, his maturity, his status as a senior officer, his former experience as a commanding officer. He has worked with law enforcement in the past. He was voluntarily subject himself to an interview with Rock Police Department when he voluntarily drove himself over to the police department, sat down with the investigator, and gave a voluntary statement. He was at no point threatened or coerced into being there, giving the statements that he gave. The defense, I'm sure, will argue that the specific phrase that Madison was never alone with Aiden, they'll argue that that is not in that video. I would argue that that statement is in that video specifically. It's through his actions. The committee leader asked if Aiden was ever alone with the girls, and you'll see that committee leader nods his head in the negative, and then goes on to describe all the locations where Madison and Emily were without Aiden dealing. So in the totality, he is denying that that the girls were, that Madison was ever alone with community league. Specifically, he said that Emily was alone with Aiden, especially leaving out Aiden. So Your Honor, in that interview, the accused does, and it is nodding of the head in giving the description of all the other locations where Aiden was, leaving out that he was at one point alone with Madison, is making the statement to CJIS that Madison was never alone with Aiden. Regarding the interview from June of 2018 with Special Agent Nigo, who once again, the accused voluntarily came into the Coast Guard Academy, a location that he had been to, that he served and was assigned to, was comfortable with, has worked there for years, voluntarily came in after negotiating with the agents about his schedule and what would work well for him. So he picked a date to come in and speak with the agents. There's no coercion. There's no abuse by Special Agent Nigro. We'll see in that interview, again, less than an hour. Both these interviews are fewer than 60 minutes. This is not a protracted, abusive interview, and they should not be thrown out at this point. So, Your Honor, based on those comments and the evidence and the arguments that we put forward in our response, the government has nothing further to provide this court.
Trial counsel, can you please provide a response today? Their last paragraph was that essentially you did not provide notice of his interview prior to arraignment. Can you just respond to that?
Yeah, so you cut out just a bit. Could you please
Sure.
repeat that?
The last subheading in the defense motion, paragraph Roman numeral 5, which starts at page 9 of their motion, is their argument is that the government has not provided timely notice of this interview prior to arraignment, in violation of kind of a Section 3 disclosure here. Can you just respond to that, please?
Your Honor, I would argue that the defense did have all the relevant discovery for this specific issue back in June of 2019. If they weren't aware that they could have played or had some problem playing with it, the defense then had the obligation to come forward and notify the government of that. That did not happen.
Good. Okay, thank you, counsel. I have nothing further for you, trial counsel. Do you have anything else?
No, thank you, Your Honor.
Okay. Lieutenant Phipps?
Yes, sir. Let me begin by just addressing two of the arguments the government just made that are wholly unsupported by the evidence, which the court will see. We'll work backwards here. Number one, the court asked about the notice requirement. To notice the defense of any statements of the accused the government intends to introduce prior to arraignment. We've already been through this on the record. We talked about this in our good cause statement. I think the government even acknowledged that we provided this item of discovery after arraignment. It's offensive to suggest that we had all the discovery we have today back in June of 2019, because we simply didn't. We certainly didn't have this video, and we've talked in excess about the lengths we went to try and play this video. So, arguments have to be grounded in the evidence before the court, Your Honor, and look at the enclosures we provided, and when this discovery was actually provided to defense. It's abundantly clear we didn't have this before arraignment. That doesn't satisfy the court's inquiry when it comes to, hey, did you notice this statement before arraignment? Because they did not. Number two, and we'll discuss this more in our UMC motion, but when we looked at this video recording of this interrogation in 2015, and then we compared it to the only evidence we had, which was this summary that Detective Nordstrom had written about that interrogation, which the two conflict greatly, and the question arises, where is the government getting this charged language from? Because there is no statement during that interrogation. If your copy doesn't work, we'll try and get you the copy that does work as soon as possible.
Appreciate that, yeah.
We'll rectify that for the court. But watch it, you'll see that there is no statement that Commander Ely makes. And
Okay, so let me stop you there. So we're in a suppressing of statement. So, you want to suppress a statement that is not made. That seems like an affirmative defense and not a suppression issue, right? What am I suppressing a statement that's not there? That seems to be a defense at trial, or a 917 motion, or...
We're asking the court to suppress that entire interrogation, Rob.
So usually you suppress based on a statement that...
That's not the basis for suppression, Your Honor.
Okay.
I'm just highlighting this particular fact. We're learning this evidence as we go, as we finally get to view it the first time. And it just plays with this broader issue that we've been tackling with throughout this litigation, which we finally get to see this interrogation, and we ask, hey, where is the actual evidence for Charge 5, for example, where the government has charged Commander Ely with obstructing justice by making a very specific statement that doesn't appear anywhere in that interrogation?
Regarding a statement, in the definition of a statement, do you agree or disagree that a head nod in the negative, if you ask me a question and I say no with my head like this, I'm shaking my head no, that can meet this definition of a statement?
Your Honor, watch the video. What Commander Tagliari was a gross mischaracterization of what's in that video. And that's why I'm addressing this.
Okay, so
That's yes, sir.
Okay.
So, theoretically, yes, a head nod could be a statement, right? That's not what the government's charged, right? The government hasn't charged that he nodded his head in response to a question. The government's charged he made a statement, and what's more, that just never happened. I mean, that's why I'm addressing that. It's a mischaracterization that needs to be highlighted for the court when you go back and finally get to look at this interview and judge for yourself what happened in that interrogation room. So let me just go back again and talk about why we're suppressing this, and the government's failed to address any of these arguments, which is coercion. A coerced statement doesn't require physical threat or violence or anything like that. We know this is a totality of the circumstances analysis. And what we're talking about in December of 2015 is Commander Ely, who's already been through a contentious divorce by this point in time, and is already aware of some of the accusations his ex-wife throws around, blatantly false accusations designed to embarrass and humiliate him. We're talking about him showing up at his daughter's school expecting to pick up Madison for Christmas, 2 days before Christmas. And instead of Madison, there's Dennis Dowdell and Detective Nordstrom and another police officer from the Stonington Police Department. And they do tell him, your daughter's not here, you can't pick her up. We need to ask you some questions down at the station. And what you will see, the reasonable inference from this set of circumstances, this set of facts, and we'll support this with the affidavit we're going to provide as well, is that what choice does Commander Ely have at that point in time, where the only thing he wants is to see his daughters for Christmas? If I don't go down to that police station, I'm not going to see my daughters. That's not a choice that he's being provided with there. Because he's a father who cares and loves for his daughters, he's compelled to actually go down there and sit in this interrogation room and suffer through these ridiculous accusations from this detective, this law enforcement officer, and then 5 years later, again, have them somehow sworn and preferred on a charge sheet against him. That's what makes this involuntary. The fact that he is there under the mental duress of not being allowed to see his children because his ex-wife, yet again, has made an outlandish, absurd allegation to deprive him of his daughters, to deprive him of the access he enjoys as a parent, to deprive him of being able to just be there for his children over Christmas. That's what we're talking about. That's the coercion, Your Honor. And the government has provided no evidence to rebut that coercive element at all. And again, when you look at this interrogation, when we get you that playable copy, pay close attention to the very beginning and throughout, Commander Ely's affect, the fact that he cries, the fact that he's worried about his kids, the fact that he cries about being concerned for his kids and what this divorce is doing to them, that is what he's feeling. That is what he's responding to. And pay close attention to whether or not this statement was ever made, which it wasn't. Because the reason I was getting into this line across with Detective Nordstrom is her testimony was not very credible, and that's going to become apparent when you look at that video. We included her summary of that interrogation as an enclosure to our motion, and we've included the interrogation itself. Compare and contrast the two, and the court will see the summary is not accurate. And many things she says are not accurate. And she conveniently forgets facts that she apparently reviewed. Because the bottom line is, she doesn't want to help advance the defense's case. She said that. She told that to me. She said that on the record today. She has an agenda here as a biased investigator who apparently, and probably respectfully takes her job as a child victims investigator seriously, but she's a biased investigator with an agenda in this court-martial. And when you receive an affidavit that rebuts some of the things Detective Nordstrom said, the court should consider Detective Nordstrom's credibility. And again, look at the interrogation, look at her summary. When it comes to the CJIS interview, the issue here is the lack of a rights advisement, because we're now talking about military law enforcement agents who are subject to the UCMJ who are required to deliver 31B rights advisements and advise a suspect of the nature of the offense of which they're suspected. And
the case law is pretty clear, counsel. It doesn't have to be every conceivable charge that he's suspected of, right? He has to be given notice of the nature of the offenses.
Correct, Your Honor.
Okay.
But there's a distinct difference between suspecting him of raping a child or communicating a threat, endangering a child. Right? Those are distinct offenses from obstructing justice, which is charge 5 on the charge sheet, which is based solely upon, I'm not sure how, I think solely upon just the one paragraph summary that Detective Nordstrom wrote up on this interrogation, the video of which we only received after arraignment. But that's something that Special Agent Nigro used, this summary, during his interrogation of Commander Ely. He tried to ask him about that, and he never advised him that hey, I also suspect you of obstructing justice during that interrogation. That's distinct, and that was required. And when you look at the interrogation, they don't ask Commander Ely once, hey, did you ever do these terrible things to your daughters? And he denies it, because he didn't. They ask him again, and again, and again. There's at least 3 occasions that we can identify in that video where they asked him, after receiving an affirmative denial, you sure you didn't do this? You sure you didn't do this? At no point did they stop the interrogation and advise him, well, I think you're lying, and so I'm going to advise you that we have this law in the military called false official statements that's prohibited by Article 107, so we suspect you of doing that. Like, when I ask you this again, just be advised you don't have to say anything. They never stopped to give him that rights advisement. And so that's the issue, is, yeah, they gave him some rights advisements, but they didn't actually orient him to the nature of 2 offenses with which Commander Ely is now being charged. And that's what makes that statement involuntary, sir, and suppressive. Other than that, I stand on my pleadings.
Okay, the one other question I have, right, because you accurately discussed as far as, or identified, when we're talking about coercion and the voluntariness, about the totality of the circumstances. The trial counsel has brought up the wealth of career experience and the seniority of your client. How is that balanced against the concerns that you have about coercion? This is certainly not an E3 who's been in the Coast Guard for 6 months, right, and has a low ASVAB score. This is an accomplished senior officer here.
Yes.
So I have to factor that into the totality, correct?
You do, and what I would say is, regardless of what rank Commander Ely happened to be at the time, that he arrives before Christmas to pick up his kids aren't there and he can't see them, that's going to affect an 05 as much, possibly more, than an E3. Especially given the unique set of circumstances that Commander Ely found himself in in the years after his divorce from Laurie Dowdell, who, remember, we've evidenced this to the court before, her family had pursued baseless allegations back in 2012. That's in the record about this fall down the stairs. We've talked about all that. He's already lived through this. And what he's concerned about is the police telling him, hey, you can't see your daughters. And he's acting as a father, and that's what matters there. That's the coercion, sir.
Okay.
Any other questions, sir?
No questions for me.
Thank you, sir.
Trial counsel, this is your burden. Do you have any responses?
Yeah, just one final note. As we brought out in the government's response, the accused acknowledges that he told Grant Police that Aiden was never alone with Madison in his interview with Special Agent Nigro in June 2018, and that back and forth were, I believe it's at minute 16, where Special Agent Nigro asked him about inconsistent statements that he gave. The accused acknowledges that he did, in fact, give inconsistent statements. So, I would say, based on both of those statements, it shows that the accused did make in the statement to Bridget Nordstrom that was not accurate. And when we look at the totality of the circumstances of both these interviews, once again, as the court noted, this is a mature, experienced senior officer who is familiar and comfortable with law enforcement and has worked with law enforcement in the past. These interviews were not coerced, so there is no evidence that anybody told, especially the accused, that he would never see his children unless he decided to do an interview with Groton Police Department or Special Agent Nigro. There is no coercive impact of the interviews that we have from Groton Police or Special Agent Nigro. And for all those reasons, Your Honor, the government requests that this court deny the defense motion.
Very well. Defense counsel, do you have anything else to add?
I do, because it actually brings up a good evidentiary point. Commander Talley just highlighted a colloquy between Special Agent Nigro and Commander Ely on this video that you will also have an opportunity to watch. Number one, the assertions of fact about the Nordstrom interview in December of 2015 come entirely from Special Agent Nigro, and they're not actually acknowledged, confirmed, or denied by Commander Ely. He talks about, hey, didn't you say this, so on and so forth, and then Commander Ely, you'll see in the interview, says, let me just tell you about that interview, that interrogation. I went in there, I had no idea what was going on. I had no idea why they brought me in there. He actually says that goes to the coercive nature and the voluntarism of statements to Detective Nordstrom. And then when I went away, I thought about exactly what had happened that weekend with Aiden. And I'll tell you what, bear in mind, we're talking about a man's memory, right? In 2018 and something that occurred in 2015, the exact statements he made. So I don't know if the government's relying upon that to prove up Charge 5. But he gives this memory of, well, I think I spoke to Aiden and he said I was alone and then I told Detective Nordstrom that. So anything that's exculpatory, it doesn't prove up the statement they've charged. And I bring all that up to just, again, talk about another reason why this statement to Nordstrom certainly needs to be suppressed. And it's a simple 401, 403 relevance argument, which is the charge itself, Charge 5, is unsupported by any evidence from Commander Ely. And the court will see that. You look at the interrogation. And so, how does this interrogation even come in? Because it doesn't prove that charge, and it's also prejudicial because all it really shows is Commander Ely being humiliated by a Groton police officer as a direct result of, again, his wife making these absurd allegations. So there's a distinct prejudice in this interview as well, which is the government has charged something that's unsupported by the evidence without looking at the interrogation, presumably, and then they intend to bring this in.
Again, we're talking suppression, and you're talking relevance over here. That's not part of the suppression analysis under the MRE 300 series.
I know, I'm bringing another argument in, Your Honor.
Sure, and that I'm going to parse that. Thank you for bringing that up. I'm not considering that for this motion.
Yes, sir.
Okay. All right. Thank you, Counsel. I understand. All right. I will issue this ruling as quickly as I can, hopefully within the week, as council prepares for trials. All right, council, it is approaching 1400 here on the East Coast. I'm going to break you for a lunch break. My intent is to try to make it through the rest of these motions today, and I'm getting a nod from the defense counsel. Trial counsel, I assume you. Yep, thumbs up from trial counsel. So, how long would you like for the folks here in Washington? How long would you like for a lunch break?
Short as possible.
Short as possible, sir.
30 minutes. Does that work?
Yes, sir.
Trial counsel, SVCs, does that work?
Yes, Your Honor.
Okay. Court staff, does that work?
Yes, sir.
Okay. All right, very well. The time is 1400 on the East Coast. We are in recess for the next 30 minutes.
All right.
Carry on, please. Thank you. Counsel, we ready to go back on the record?
Yes, sir.
Can you hear us? Can you hear us?
Yep, no, gotcha.
That's everyone, right? Because Lieutenant Commander Lons... Yeah, okay.
This court is called to order at 14:45 Eastern. All parties present when the court last recessed are again present. Okay, counsel, based on our discussion this morning, the next motion is a motion from the defense for a competency exam of ME. That is entered in the record as Appellate Exhibit 165. The government response is 166. The SVC response is 167. And the court's ruling will be reserved as Appellate Exhibit 168. This was one of the motions that I asked for a statement of good cause. Briefly, defense, I understand. I think the starting point would be when you discovered evidence of hallucinations would be the starting point that I would see that you have as your starting point for this discussion. Lieutenant Commander Haley?
Sir, if I may, just before we get into any of the substance of this particular argument, would just ask, in light of this motion being at least partially based on 513 material, at least some of which was not in the 9 November disclosure, because this motion was filed on 6 November, we would just ask that the court close the courtroom for this portion of the hearing. I understand, it doesn't look like we have many spectators in the room now, but I can't tell this online.
And just from the defense, we certainly would request the presence of both Mr. Smith and Ms. Mullins. They are detailed members of the defense team.
Okay. So, yes, we will functionally close the courtroom. I will just ask for, Chief Mills here, our bailiff, to just keep an eye out if someone comes in to politely...
And additionally, Ellen One French returns. She is a detailed member of the defense team.
Sure. So anyone but Ellen One French, all detailed members of the defense team. The court is now closed functionally for the remainder of this discussion. Okay, Lieutenant Commander Newstad.
She's actually she's French? Yeah, she is. Okay. Sorry, sir.
Yeah, no, that's fine. If you were tracking, really, I think good cause to me, my question starts upon the date when you found out about evidence of hallucinations. That, to me, is where your clock starts.
Okay, yes, sir. So, this is, pardon me, well, I won't say that we'll rest on our good cause statement. What I do want to do is just point you directly to the paragraphs that we think apply to the good cause here, and then I'll expound upon additional evidence for good cause. So, paragraphs 13 and 14 in our filing for good cause, which addresses the fact that Mr. Smith interviewed Ms. Wiley on 27 August, which was 2 days after the previous court-ordered, deadline for motions. The last court-ordered, in a court-order motion for deadlines. Now that was extended to the 28th, but I mean, we were obviously on the 27th. We were in the final stages of submitting, preparing to submit our motions that we submitted on the 28th, and then, further evidence came to us on 7 October, which was the enclosures that we got from the West Vine School that documented the information from her teacher about her reputation at the school, and then also that disclosed to us 3 of the prescriptions that ME has, and that was our first time seeing that information. And then additionally, subsequent to our filing of this motion, more information came to us, to our way, in the way of Appellate Exhibit 164, of which, the specific content I will address further on the merits.
Okay. Trial counsel, do you want to comment on the good cause for this motion?
Your Honor, excuse me, just briefly that while some of the evidence that discussed is recent, but these have been ongoing, no doubt, generalized issues throughout the course of this litigation. So it shouldn't come too much of a surprise to the fact that they needed to be,
Okay, understood. So I'm making a finding here. I'm finding for this motion, there is good cause to file the motion at this time, and the finding is based on the fact that the information first was discovered at the end of August, and in the midst of our last round of litigation, which was subject to the 513 litigation, which the defense filed on a timely basis, and then subsequently built on further discovery, which for this court order number 6, I find is timely. So I find good cause for the filing, and Lieutenant Commander Newsad, if you're arguing this motion, is there any additional evidence in support of this motion?
Yes, Your Honor. So I'm not going to submit it unless the court wants me to. I'm not going to submit it as a defense enclosure, but with the court to consider Appellate Exhibit 164, which I will refer to specific parts of that in my argument.
Okay.
And then just, I think with all this, right, Appellate Exhibit 164 is the redacted medical record.
Yes, it is. Appellate Exhibit 164 is what the defense team received on 9 November.
Yes.
Okay.
Okay. So let me just put it, I'll start with that and just put that as sort of as a factual basis, additional stuff on the record for my argument. So if you go to Appellate Exhibit 164 and look at the file that is labeled RI Hospital Hasbro, I would specifically point the court towards pages 3 and 4, page 6, and page 13. Amongst those pages, what you'll see, and some of this, frankly, is scattered throughout that document, but reports of Emmy thinking about stabbing herself with a knife. And again, just to clarify, that document is dated 1/9/2020, but it covers the period for which Emmy was both, I think, in the Bradley Hospital and the Hasbro Hospital, covering dates, from January through March of 2020. So thinking about stabbing herself with a knife, hearing her voice in her head telling her to do things, including to hit herself in the head and to cut herself with a knife and throw herself against the wall, which she actually said she did. That she tried to stab her grandma with scissors, and that she kicked and hit her as well, and she tried to push her grandmother down the stairs. A diagnosis of ego-dystonic CAH, which I believe is congenital adrenal hyperplasia. That's not, I did not see that defined specifically in there, but again, this is my having to, and SVC pointed this out, that looks like defense counsel has just used the internet to figure out some of these things. Like, this goes to our request for Dr. McDonald, right? We know at trial we can't just say, I looked this up on the internet, members, take my word for it. But my reading, my most likely reading is that that's congenital adrenal hyperplasia. And then finally that she's using profanity and expletives towards her caregivers. Actually, two additional things, of course. There was a prior medication of clonidine, and then lastly, that Emmy denied visual hallucinations. That's mentioned throughout that document as well, which I think that's significant. Why did they even address that? Because obviously the voices in the head, it's very clear, right? Implication, they considered the voices in her head as hallucinations, and that's why they went out of their way to document in the paperwork that she denied visual hallucinations. And as we know, we have evidence of that later in August of 2020. So that's the additional evidence I'd like the court to consider for this motion. Unless there's questions about that additional evidence, I'll go into the merits.
No questions.
Okay, so I realize probably as a threshold matter, and I addressed this up front in the beginning of my argument, is that, well, is this even an option for the court, to order a competency exam? So I think that we've shown at a minimum to the court that certainly CAF or no other competent military court has ruled that 18 U.S.C. 39C does not apply to military courts martial.
Okay, so I agree with you there.
So at the point there, then we have to look at, well, have other parts of that statute been looked at by CAF or the criminal courts of appeal? And they have. And so specifically, CAF has looked at 3509 on more than one occasion. And the case I would point to most importantly is the McCollum case, where they were discussing changes to, so they were looking at the Craig case, which I know has come up in our litigation before, that has to do with alternate examination methods for child victims and witnesses. And sort of the consideration was, well, does Craig apply? How the changes in the federal system apply here, and how does the statute apply? The court very much looked at 3509 and looked at what the federal government did with their MREs and how they applied Craig and 3509 in their courts, and they literally used 3509 to define MRE 611 Delta. So the court used 3509 to supplement their meaning interpretation of MRE 611 Delta. I think while they never explicitly said anywhere in their
so that's statutory interpretation to me, right? If it's not defined on its face, and then you look to the MREs, look to the case law. If that's not there, then they look to the federal statutes. So that was my understanding of their analysis there. To me, that's different. That's different than we are applying this federal statute to.
So I'm not resting my argument just on the column and throw my paper down. So so further, right? If we look at what the other courts have done, the other courts of appeals, none of the courts of appeals have addressed this on the merits, right? 3509 Charlie, but they have looked at India and Mike, and I mean without question in Guy, the court explicitly stated, and that's the Army Criminal Courts of Appeals, and that's just last year, explicitly stated that 3509 Mike applied to military and applied to the courts martial. Very similarly, the NMCCA applied 3509 India as well to the military and courts martial.
And that's the Brown case?
So yes, that is the Brown case. Yes, sir.
So I read Brown, I read the CAF cite of Brown, which is footnote 4, which then cites the NMCCA, that I read that as just pointing out that federal courts acknowledge that victims have the right to be accompanied by adult attendants, like as a practice, a synonymous practice. I'm not sure I read that as this applies to military courts.
I find it hard to read. I understand they put that footnote in there, I understand that, but it's hard to really step back, read that opinion, and not realize that NMCCA literally says that applies to courts-martial, much like, I think, in this case, Charlie should apply. And the reason is, they can put that footnote in there, but the reality is, nowhere does it state in the MREs that, specifically, right, that, you can have somebody sit next to a child witness at trial. But 3509 does, and what the judge did, the trial judge in that court, he said, hey, 3509I, you can do this. And then NMCCA said the trial court did not abuse his discretion in letting that happen. So it's sort of like connecting the dots, but NMCCA adopted that position and certainly did not counteract the reasoning that the military judge used to allow that to happen.
So I think what's not in your motion, and I hear you saying, right, is this is a MRE 101 as far as authority, which MRE, the sources of law, 101 Bravo says, in the absence of guidance in this manual or these rules, court-martials will apply, first, the federal rules of evidence in the case law interpreting them, and second, when not inconsistent with subdivision B1, the rules of evidence at common law. So I think that's probably, when we're talking to competence under the 600 series, that's what you're asking me to do.
It is, Your Honor. So, and this sort of the last piece to round this out is that
And so I just want to distinguish, so we don't talk past each other, right? I'm not sure I'm buying that this applies, but 101 tells me to look to the federal rules. So
I think
apples and oranges, I gotcha.
Yes,
all right.
Fair. So, and just to round that out, right? I mean, nobody should, given what we've laid out here with the law, nobody should point to MRE 601 and says everybody's competent. That's the end of the story, because the federal rule of evidence says the same thing. Yet 3509 Charlie applies in federal courts. So, I guess certainly what I started out with is there is nothing that prevents the court from applying 3509. Which I think, in our defense business, there's nothing that prevents you from applying it here. Okay. So, going into the argument on the merits here, then what we need to do and what we need to show, right? We need to file a motion and we need to show compelling reasons. And I believe that we've done that with the evidence here. I'll sort of highlight everything here again, but I cited 5 reasons. One of the reasons I cited, right, is any age. Now, the statute says age alone is not enough. But read that very clear, right? That's a natural implication that age is part of it. In fact, the whole statute's not about the competency of any witness or adult witnesses. It's about child witnesses. So the fact that Congress passed this and the fact that they wrote age alone is not enough is a natural implication that age is a consideration in connection with other compelling reasons. So here, and I think that's important because I forget if the statute defines what a child is. I'm sure it does somewhere, if it's less than 18 or less than 16 or whatever it is. So I think age matters, right? The younger, the more compelling reason it is. And what we have here, I think, is 2 things. One is her actual age at the time of the alleged offenses, which is they begin when she's, allegedly this begins when she's 3 years old and ends before she turns 6. So I think her actual age at the time alone is enough to call into question her competency. I'll ask the court. I know the court is familiar with children, and the idea of what a 3 or 4-year-old remembers alone the next day could be spurious. And then what we're talking about here is a child that will be nearly 10 when she takes the stand, and 4 years will have passed from the last date of these alleged allegations, but over 6 years since the earlier one. I cited the 40% of her life. That's from the last date of these alleged allegations. If we go to the front end of it, over 6 years will have passed, which is more than 60% of her life.
So this is very similar to my earlier discussion with Lieutenant Phipps, right? As far as kind of weight of evidence, or I don't know who I was talking to, maybe Lieutenant Brett, but we were talking about, hey, you have that ability, you have bias, or you have inconsistencies that you pointed out in your motions. You've had the relatively young age, the time between the alleged offense in testimony. That goes to weight of evidence, and I'm not so sure that overcomes the presumption of competence.
Yes, Your Honor. And as you well know, I know you read our motion. We didn't rest our argument on it. I'm asking the court to consider that as one of our compelling reasons. The last thing I'll point out with respect to that, I'm going to talk secondly about our alternative remedy, but the case United States versus Largo was sort of odd, where the defense didn't actually ask for a competency exam, and so the court did not analyze that under 3509, because the court fully acknowledged, like, one of the requirements of 3509 Charlie is you have to make a motion for a competency exam, and the defense didn't do that. But the court took that child back into chambers, I think with a rep from trial counsel, rep from defense, or whatever. They cleared the courtroom, and they ultimately found, the child didn't have present personal knowledge of the accusations, and a large part of that was age, right? It was 4 to 6, and the court cited that in its ruling, that an age. I mean, ultimately, the court hung its hat on the huge inconsistencies between what was alleged and what the child could relay. But they sort of explained that, the court's belief that was in large part due to age at the time of the offenses and age of the witness at the time. All right, so I'll move past the age issue. The bigger ones are what I read off in our argument, which is reason 1 and 2. Reason 1 are her actual mental health diagnoses, to which now we can add one more, the ego-dystonic CAH, and to go with the PTSD and the ADHD and the aggressive behavior. That and the symptoms. So it's the diagnosis, but then the specific symptoms. These hallucinations, these visual and auditory hallucinations they're significant. Those are compelling. Seeing or hearing hallucinations naturally gives cause to question whether, one, a witness knows the difference between truth and fiction, or reality and unreality. So I think these diagnoses certainly call into question the competency, not just the credibility. And when we're talking about this too, right, just as a starter, like, competency and credibility aren't mutually exclusive. Just because something goes towards a witness's credibility doesn't mean that it might not simultaneously go towards their credibility, looked at in a different light, but the same facts. And so I think, here in this case, where we firmly believe, right, and we've let the court know our theory of this case is that the ME has been manipulated and coached, and probably is going to walk in this courtroom and if she testifies, is going to believe that these things happened. And based on our theory, right, that alone calls into our theory calls into her competency, and we have evidence to back up why that's not true, or why her competency is questioned. So the medications, reason number 2. So one of the things I want to point out is that SBC sort of poked us and said these side effects. 2 things about these side effects. Poked us and said, "Looks like you looked those up on the internet." Yes, I looked those up on the internet. Okay. Again, this goes to Dr. McDonald. I know in court, I can't just say, I can get out from her what she's taking, but then I can't just profess to say, well, the side effects are this, and I need an expert. We need an expert to do that, a psychiatrist who can prescribe medicine and talk about these illnesses and how the medicine, the side effects and the contributions. But SBC also suggested that we did not connect these with the evidence. And I'm dumbfounded by that assertion. So let me just go through it here very quickly. But and I may butcher some of these words, right? But guanfacine. Known side effects include hallucinating and suicidal thoughts. Those are documented in the record. She has both visual and auditory hallucinations, and she has expressed suicidal thoughts and self-harm. Okay, so we're not just supposing she may have these side effects. What we don't know is, are these side effects of the medication, or are these pre-existing connected to some other mental illness like schizophrenia? Right? We don't know that. And that goes further why the competent exam ordered by the court should involve a psychiatrist, because the court won't know, and we don't know, right, without expert help about whether these symptoms that she's exhibiting are connected to side effects of the medication, or are these separate mental health diagnoses that have gone either undiagnosed or, as I'll cover here in a minute, that haven't been discovered to us. So, Zoloft, the side effect of Zoloft is suicidal thoughts, which we have evidence of in the record. And then finally, methylphenidate, a side effect of that is psychosis. Again, I don't have evidence in the record of what psychosis means, but I did some internet research. Right? Psychosis is a mental disorder characterized by disconnection from reality, resulting in strange behavior, often accompanied by perception of stimuli, voices, images, and other hallucinations. Okay, so we have evidence in the record that are strongly connected to the side effects of all of these prescriptions. Okay, so all of this is very strongly, it calls into question and presents compelling reasons why the court ought to do a competency exam in this case. So speaking of the hallucination and sort of the possibility that these symptoms are not even connected with the medication, but of something else, I will note that we know from Mrs. Wiley in the record, right, the hallucination that happened in August of 2020, just recently here, that she was asked, EE asked Mrs. Wiley to help. And then I don't know I don't know the full facts of this, if Virginia Dowdell and Dennis Dowdell were already there, or if they arrived after they asked Miss Wiley for help, but they show up, or they're there, and they say, we're going to take her to the hospital. Okay, so we've asked for all the records in this case, right? The 515 records. The court presumably got what we asked for, and we have no evidence in the record of this visit to the hospital related to this hallucination. So that's fine. I'll put that aside. But my point is, we know there is an instance of a hallucination where she was taken to the hospital, and we've not. That record has not been discovered to us. My point with bringing that up is that it calls into question that there are other visits. I mean, if that was like the immediate response, like, oh, we're going to the hospital, hallucination, like, one, we don't have record of that, but it calls into question that there were probably other visits to the hospital involving, significant mental health issues that we don't have a record of. Again, all of this calls into the further concern of our compelling reasons why the court ought to order a competency exam. The last three compelling reasons, we talked about age, so I guess the last two is that the forensic interviews very much implicate that her memories have been tainted. If we put aside our theory of the case, what is not in question is that she told, initially, she told the first forensic interview in 2015 that her mother told her that Commander Eby threw her down the stairs. And then 1 year later, so that alone is evidence of tampering with her memory. 1 year later, she tells the forensic interviewer, my dad threw me down the stairs. I remember it. So now, I mean, it's like perfect evidence of the attempt to taint it, and then it has been tainted. So that's another compelling reason for these very serious charges for the court to order a competency exam in this case, because we have evidence that her memory has been tainted by her mother. Finally, we have at least two serious incidents, I think three serious incidents of Emmy telling lies in situations that will be similar to her taking the stand here. So the cornerstone of competency exam is really, so there's, the case law sort of suggests there's, I guess I want to say four things, right? The ability to observe, remember, relate, and then know and understand your oath. And you may think, okay, no one understanding your oath is maybe the cornerstone of this. Well, in 3 instances where, ME should, as a 9-year-old, you should, I don't think that ME is going to come in here and treat this different than some of the important moments in her life where she knows she's supposed to tell the truth. She's going to come in here, she's not going to be thinking about perjury, she's going to be thinking about this is a intimidating situation with adults and I'm supposed to tell the truth. Well, she has that at school, yet her teacher said she tends to lie at school. So she's not, she doesn't seem to understand her duty to tell the truth to her teachers at school. She, being interviewed by Dr. Leidy, made statements that are just totally unsupported by any evidence in this case, right? That her dad and brother held a gun to her head and that her dad, molested her every night.